It's usually in there, and I catch it on the fly and leave it off. So if in fact we're not finding it is in there when I'm reading, I'm pretty good about not saying anything about alternates.
I thought it was usually in that sentence.
Yeah, after the final instructions are given, you will retire to consider your verdict. This is the way it should be. It doesn't say, the standard says the alternates will be released and you will retire. So this is in perfect condition, in my opinion. Mr. Marchese, you seemed like you wanted to say something.
Yeah, I need to address the court before we get started with trial.
That's not a problem. We aren't ready to start because we're waiting for speakers. So, whatever you need.
We can do it now. Your Honor, there's been a lot of transfer back and forth on strategy, tactics between myself and Mr. Summers. We've had disputes about this since my beginning.
Since your beginning in this case, but not your beginning.
Exactly. Thank you. So, on counts 1 and counts 2, the defendant is charged with the most serious crimes of attempted murder.
Yes.
And so, from the story and the scenario and the way that I understand the facts to be, I believe that Mr. Summers is entitled to a defense of abandonment of purpose. And so I filed an invocation notice of intent to use the affirmative defense of abandonment of purpose. It is in Florida Statute 777.04, subparagraph 5, subparagraph A. Basically, as I explained to Judge Fuson, I shoot at you, but I miss because I'm a bad shot. It's still attempted murder. In this case, Mr. Summers is charged with attempted murder, one with a pillow, one with a rope.
With a what?
With a rope.
Okay.
And so the testimony, will be that he stopped. He abandoned that person. And in that, under the statute, that is an affirmative defense that if in the commission of the crime, he decides to back off and abandon, you rob at a bank and he decides this isn't a good idea, I leave, or attempted murder with a pillow, or he decides that this just isn't what I should be doing, and he stops, I believe we have the affirmative defense of abandonment of purpose, and I have asked for a jury instruction that I have submitted. Now, when Mr. Summers decided to represent himself, the first thing he did was strike that affirmative defense. I don't know. But now that the case is back with me, I want to give all notice to everyone that I am re-invoking the affirmative defense of abandonment of purpose for count 1 and count 2 and attempted murder. And I ask for a jury instruction on the same, pursuant to Florida Statute 777.04, sub 5, sub 8.
Okay, before I can decide whether a jury instruction is appropriate, these discussions, and usually it's self-defense, come up at charging conferences where I have to make a determination whether there's any evidence, and the bar is very low, any evidence to support the instruction. I'm not anywhere near a stage that I can make a determination whether there's any evidence to support such an instruction. The issue here is the withdrawal of, and whether you would ever even be able to make that argument that there is some, as minor as it may be, evidence to support such an instruction. So I'm not for prejudging the determination because I haven't seen any evidence, and no offense to you, but what the lawyers say is not evidence. So if I was to get past this striking of the affirmative defense and revert back or whatever, then I would allow you at the charging conference to make argument that there is some evidence to support a instruction of that nature. So I just want to make sure we all understand what. But what is the state's position regarding the defendant when he was represented pro se striking the abandonment affirmative defense?
Judge, it's the state's position that it's not going to qualify and that it should not be read to the jury. And
when you say not qualify, is it because you don't think there's going to be evidence to support it?
Correct.
We're not arguing that now. We're arguing simply the legal issue of the striking of it, and whether or not at the charging conference the defense would have the opportunity to say, we request this, and I say, what's the evidence to support it, and then they have to establish throughout the course of the trial there was some slight evidence to support it.
Well, Judge, Case law is very clear that if there is evidence that would support a defense and the defense requests a jury instruction as to that, it should be allowed.
Okay, even if they struck. It's the only thing I'm trying to get through is that you have to raise affirmative defenses. Right. They did, but then he struck. So it sounds like you're okay. You want to put the argument off until the evidence is in. We do a charging conference, and if there's any evidence to support it, then I should give it.
That's correct.
Okay, not a problem. So don't worry about the striking of it.
The state would ask that there be no reference by defense counsel in opening statements as to that abandonment, as there is no evidence of that at this point in time. And
well,
then
there's no evidence of anything prior to opening statements, so that would make both of you have to just stay seated and not be able to say anything during opening, because there is no evidence in the case at this time. Right. What about self-defense? They get to argue not argue, you can't argue in opening, but they get to talk about self-defense if that's their theory of defense in opening, but then they might not get the instruction if at the time of the charging conference there's been no evidence to support it. So why should I treat the abandonment in opening different than I treat self-defense in opening?
Well, Judge, I would argue that it was similar to self-defense, but secondly, the abandonment language that the defense is requesting is not even a part of the standard jury instruction for attempted murder. Secondly,
I'm not going to give the instruction unless there's any evidence to support it, and then if I decide that there is some evidence to support the allowance of the instruction, I will look to see if there is a standard instruction on it, and that would be the instruction I would most likely give. They certainly can argue whatever they want, that they want some alternative to but we don't get there if I don't decide there's any evidence to support it.
I agree.
Okay. And you're telling me there's not going to be any evidence, therefore I shouldn't allow them to argue it in opening. And I just don't think that that's the status of the law. If you have some authority, if you want a moment to present some authority to me that says I can't allow them to argue not argue, I keep saying argue, and I apologize, to present their theory of case in opening because there is no evidence of it, I would love to see it. Am I right? Law students, be careful not to make promises in opening that you can't keep. There's no rule, but if you talk about things in opening that don't come in or that you don't get in the end, then that's what you suffer. I tell them to be careful.
Judge, the state's just making the objection for the record. And
what objection are you making? To them mentioning
yes.
Abandonment in opening?
Yes.
Because there's no evidence of it?
Exactly.
Denied.
Judge, as well, the instruction he wants to use is not in the standard instruction. It's not part of it's not the law. He wants to add it in.
Stop. Okay, wait a minute. Is there a defense of abandonment?
Not to attempted murder. Not the way he wants it put in. He's prepared
in any way. I'm not saying, like I said, when we get to the charging conference, if I determine there's any evidence to support the defense going to the jury, then I will determine what instruction goes to the jury. If there's a standard instruction that's written by the Florida Supreme Court, then that's usually what I use. If they want to argue some other, I'll listen. But we're splitting hairs here, and is it the state's position that there is absolutely no defense of abandonment to attempted murder? And if so, then let's flesh that out. And if that's true, then I will tell them that they cannot talk in opening about something that doesn't exist. However, if there is a defense of abandonment in whatever form to attempted murder, then they're welcome to suggest it in opening and then come to me in the charging conference and point to what evidence supports it before they get any instruction on it. Don't worry about what his instruction says. Is there a defense of abandonment that could be raised under the proper form of the instruction to attempted murder?
The way he is going to present it to the jury with the instruction he has prepared is not the correct law. It is not the correct law, and it's going to be confusing to the jury and misleading the jury.
One of the main objections during either opening or closing is misstatement of the law. So be ready. If he says something in his opening that is a misstatement of the law, I will entertain that objection. And I suggest that you have some legal authority, because I'll ask you to approach. And we're doing research as I speak. And if you are right, he misstates the law, I will sustain your objection, and I will tell him to rephrase or to change or to abandon and to not mislead the jury and to misstate the law. I will not let that happen.
Yes, Your Honor.
Thank you. What? You won. Don't misstate the law.
I got you. I got a particular statute I'm quoting now.
Well, give me the statute so that my staff attorney can have it all up. So if you misstate the law, or if they think you misstate the law, I can cross that bridge when I come to it.
Absolutely. Florida Statute 777.04, subparagraph 5, subparagraph A, abandonment. Attempted murder, I either shoot and I miss, or for some other reason she's still alive. She's still alive because he abandoned. Now, the only reason I bring this up now is because it's an affirmative defense, as opposed to self-defense, which is not an affirmative defense. Something like insanity is an affirmative defense. I have to tell them ahead of time. And that's all I'm doing right now, is re-invoking that to let them be on notice. You're right, when we get to the charging conference, I can tell you where I pulled my language from, and we go from there. But right now it's just about invocation.
And you're going to argue to me that the abandonment takes away whatever attempt was made up. It forgives the prior attempt. So I'm trying to kill you. I decide to stop, and that absolves me of the attempt that I made to kill you. That's your position.
It's an absolute defense of attempted murder. It's an absolute defense. Abandonment.
All right.
Well, we want suspects who are trying to commit crimes.
See, we're getting way. I apologize. I'm sorry. We can't talk at the same time. It's my fault, and I take full responsibility for that. But we will flesh this out at the charging conference. But I would like some authority. I'd love to see a case where the affirmative defense of abandonment was used in any attempt murder, attempt robbery, any attempt type charge.
I'll look. I didn't know it was going to be an issue because it's right on point on the statute.
I understand. Well, I will read the statute, and again, that's not going to be determined until the evidence is in, and the law says that you have to point to some evidence, slight evidence, to support your defense before I can instruct the jury on it.
I agree. Want another subject? Protocol.
How many subjects do you have?
Well, as many as I need to be before the trial. Protocol. I am by myself here, and I'm being tag teamed by two assistant state attorneys.
Happens all the time.
Well, no, I would think that I asked if when they argue something that they shouldn't be double teamed.
I agree. There's no rule on that, but absolutely.
And the same with objections, and the same as we go.
Absolutely, no crisscrossing or jumping objections. So whoever is responsible, for example, for that witness will make the objections during that witness's testimony. Whoever's doing the opening will make objections during the opening, and for
And that's what overlaps, Judge. I'm doing the opening, but Ms. O'Connor is handling the abandonment issue. So I apologize.
Okay. All right. Anything else, Mr. Marchese?
Not at this time.
Do we have speakers? I don't know. Did they come in?
I'm trying to untangle this mess here, and then I just need to figure out where I can plug this in.
Not a problem. My judicial assistant is coming up to assist you. I know nothing about the AV equipment in the courtroom. I'm old-fashioned.